Now, if we specifically look at it, how does the OECD model work in the Indian context? As I told you in the initial part of this presentation, most of the treaties which India has are based on the UN model, right? But there are several judicial precedents where the OECD model has been considered. The first thing we need to know is that India is not a member of OECD, right? It is only an observer, which means that whenever OECD comes out with any rules and regulations, India as an observer tells what their view is vis-a-vis what is the stand that is being taken in the OECD model commentaries or OECD draft. Now, what I'm enunciating right now are the principles which the courts have looked at insofar as the OECD model is concerned. There will be a large number of judgments which are in favor of and against what I'm going to tell you, but these are just the general principles that one needs to keep in mind when you are using OECD model as a guide or as an aid to interpretation of the Indian treaties. The first one is that the OECD model commentary will not be applicable if the language of the treaty which we are interpreting is materially different from what is there in the OECD draft model convention. In several cases, it has been considered that the OECD model commentary is not applicable in the Indian context. However, having said this, in cases where the language of the Indian treaties was similar, they did due support, from what has been placed in the OECD commentary to find out the reason why a particular term may be used in a treaty. And again, the courts have held that while this may not be binding on the Indian tax authorities, but definitely in cases where the language is similar, it can definitely be of a persuasive value. But we also need to keep in mind one thing, that India as an observer has made time to time reservations on the OECD commentary where they have indicated that we do not agree with the view or we have certain reservations on what you are saying. Generally, if you see the OECD commentary, these reservations are mentioned as a footnote, for respective countries who may not be member of OECD but are observers. So what is the stand of the court or the judiciary on the reservation made by India to the OECD model commentary? It has been held that it is not permissible for the tribunal to follow OECD view as Indian government has rejected the OECD stand. In the case of Linklaters LLP, this is what was held, right? That the tribunal cannot follow the view of the OECD because the Indian government has rejected the stand of OECD. But then there's a decision in the case of Rights Florist, where they've said that the reservation of the government are not relevant for treaties which are entered prior to such reservations. So if, let's say for example, on 1/4/2014, the Indian government expressed a reservation on whether or not a website would constitute a PE, right? Then for the period which is prior to this period, if there is a treaty which has been entered into, so let's say India enters into a treaty with country X on 31/3/2013, then in that case, this interpretation would not apply to this particular treaty.